Good afternoon. Thank you for joining us. This week we are kicking off the copyright series. So we're here with Matt Grumbling, who's an intellectual property attorney, and he is going to kick us off right now, starting with copyright basics. Matt?
Hi, Julie. Yeah, so this week we're going to talk about copyright basics, sort of like trademark. I think everybody, you might be surprised at what you might have some copyright issues about. Because everybody's creating content these days. I just introduced myself real quickly. My name is Matt Grumbling. I'm primarily a patent lawyer. I'm a registered patent lawyer with the United States Patent and Trademark Office. I also do work in trademarks, but I also have some experience in copyrights as well. The name of our firm is Nguyen Tarbet LLC. A lot of our clients affectionately know us as NTIP or just NTIP. Here's my email up here, matt@ntiplaw.com. And there's my cell. You can either call or you can send a text to that cell number anytime you like. So I'm going to try to demystify copyrights, because I find that there's, in the popular imagination, at least, when I watch movies or television shows or whatnot, I'm often sort of amazed that writers get terms like copyrights and patents mixed up, and that's, writers live in the world of copyrights, and yet the TV writers often mix them up, and I imagine that if they can do it, so that probably reflects a common misunderstanding in the general populace. Incidentally, one of the reasons I don't tend to watch legal shows is because they often, for dramatic effect, get things flat out wrong. And so I try to steer away from those. It drives me crazy. Instead, I watch medical shows, which I know very little about. And then I play a little game I call Spot the Tort, where I try to, spot where somebody has done something where they could get sued for it. Anyhow, this is copyright basics. I'm going to try to demystify copyrights a little bit. And where we'll start off here is just I'll just give you some idea of what topics will be covered here. The first one is, we'll go through some definitions. And just to show you something, here are the copyright laws. This is an older book because I went to law school 20 years ago, and you can see the pages are yellow and are heavily earmarked because I really studied this thing. Apparently, it's all a blur now, but I really studied it hard. And so I'm going to go through some definitions. I'm not going to cover all the definitions because there are an awful lot of them. It's rather complex. But I'm going to try to hit the high points on the definitions, just so you have some basic fundamental foundation to build on here. Then we're going to talk about what can be protected by copyright. Kind of importantly, what isn't protected by copyright. How do you create a copyright? How long are they effective? I think that's kind of an important thing. It's a big thing that distinguishes copyrights from, say, patents, and because they're much longer. And then who owns a copyright? I think that's an important thing. If you're a business person, you really want to know who owns the copyright. And then in the end, I'll touch a little bit on how they're enforced. I'm not going to go in fact, all of these things are going to be, I'm going to touch them at a very high level. There are all sorts of caveats and exceptions and whatnot that I'll cover in later parts of the course. But today I just want to touch some basics here, and hopefully, if this will be enough where if you're a business owner and you start to see something, you think to yourself, that might be copied that by copyright, or that might be covered by copyright. Maybe I should call a copyright lawyer. This will kind of raise your, just raise your awareness of the issues. And, a lot of times actually as lawyers, that's what we do. And it's amazing what issues there are out there, frankly. But, we try to become familiar enough that we can spot issues, and we may not always know the law on a particular issue, but we can go look it up. That's the nice thing. There are books, there are statutes that you can look up and whatnot. So you can kind of get yourself familiar with things as you go along. Anyhow, and then, so I will talk about how copyrights are enforced to a certain degree, but not terribly in depth. So copyright is actually an enumerated power in the US Constitution. It's one of Congress's enumerated powers. And that's important because under our Constitution, Congress can't just do anything it wants to. It's limited in its power, and those powers are enumerated. The ability to create copyrights is an enumerated power. It's set forth in Article 1, Section 8, Clause 8 of the U.S. Constitution. And it says Congress shall have the power to promote the progress of science by securing for limited times to authors the exclusive right to their writings. Okay, so this clause actually covers both copyrights and patents. The useful arts are patents. Science, just knowledge. It's a word that was used in the 18th century when this was written to cover everything that was in the scope of knowledge. And they didn't have the sort of specialization that they have now. Benjamin Franklin famously was experimenting with electricity back in the late 18th century, maybe even into the 19th century. They were scientists back then were often gentlemen who had some spare time on their hands, and they did some experiments, put some papers about it. And, we didn't have, huge numbers of PhDs running around. We had, oftentimes people who had nothing more than perhaps a Bachelor of Arts or something like that, who were doing really interesting science at the time. It ended up being very fundamental. But the keywords are science. We're not talking about utility type of things. We're talking about philosophy. We're talking about basically any knowledge whatsoever. And this has been interpreted very expansively, as you'll see as we look into the statute. Authors, people who create those works of science, and again, that's a very expansive type of term. It's not limited. We think of authors usually as writers who write books or something. Author is very expansive in the way it's been fleshed out in the statute. Then the next key term is exclusive right. That is, you can exclude others from copying, from altering your work, from distributing it, et cetera, et cetera. But you don't have necessarily the right to write anything you want. That would come under the First Amendment. And then the next key term is writings. That is distinct from discoveries, which is the realm again of patents. So that's probably not real clear. The statute actually goes more in depth into these things. And so you'll find there are definitions in the Copyright Act. They're right up front. They're Section 101 of the Copyright Act. So the first thing that we'll look at is what's the definition of copies. Then we'll look at phonorecords, joint works, derivative works, works made for hire, publication. These are, like I said, this is a select group of definitions here. There are lots more of them in the Copyright Act. I think what's useful here, I've tried to pull out definitions that are useful for understanding what you can copyright and what you can't, and then who ends up owning it and things like that. So a copy is a material object other than a phonorecord in which a work is fixed by any method now known or later developed and from which the work can be perceived, reproduced, or otherwise communicated. So, and the reason that there's a distinction between copies and phonorecords is because there's a different definition for phonorecords. So the definition of copies, basically, there's not much difference between a copy and a phonorecord in the sense that they're both material objects. The work is a creation of some sort, whether it's a group of words strung together, or if you were, say, publishing a mathematics article, bunch of numbers. As long as there's some minimal level of creativity, which we'll talk about later on, that it's covered by this copyright statute. The work needs to be able to be perceived, but it can be, the way it can be perceived is you can use some sort of a device to help you. So if something is recorded, it can, if your idea is on a hard drive on your computer, or it's in the cloud, and you own that little section of the cloud that you have purchased from whoever is selling it to you, say Google or Apple or whoever, and it's fixed there in a medium where it can now be perceived. Well, you can read it on your computer, so it can be perceived, or it can be reproduced or otherwise communicated. Then you have created a copy, and that's going to be important here. So that thing fixed, it's an expansive. You need to think of it as an expansive. It's not just writing something down on a piece of paper, although that counts. That could count. It's not just making maybe an audio recording of it, but it's a very expansive kind of thing. Phonorecords, a real distinction here is that the material objects are now recorded in sounds, or they are sounds which are recorded in, by some fixed method. And there are probably some computer folks out there who are thinking, well, if a copy can be just a bunch of ones and zeros recorded on some medium, and most records now are actually digital. Phonorecords and copies sort of overlap, and that there's a good argument that that's true. Although back in the day when everything was analog, it wasn't quite so obvious. So that's why they broke out copies and phonorecords. Publication is the distribution of copies or phonorecords. So there you see, now we've gotten where we've kind of thrown copies and phonorecords into a group, right? And so, and maybe someday they'll just say copies. Who knows? The important thing here is that the distribution has to be copies or phonorecords. It's not distribution of the content. A public performance, say, of a particular work is not publication. That's a public performance, and so they're covered differently in the copyright law. A joint work. Okay, so now a work, the term work is not actually defined. So we have to infer what it means, and basically it's anything, any sort of recordation, whether making a copy or a phonorecord of some content. And we'll just, we use that term. It's not exactly what's used in the copyright law, but I think that works for us. So a joint work is work that's made by two or more authors. Remember, authors was defined in the Constitution. That's the word that was used for those who are eligible to get copyrights. So there are two or more authors, and their intention So there has to be an intention that they both contribute to an inseparable or interdependent parts of a unitary whole. So it has to be some unitary whole. There had to have been some intention that their contributions be merged. So there's some sort of a meeting of the minds beforehand. And the two or more authors cooperate in some way to make this joint work. Now, there's also a thing called a derivative work, which is where you have a work that is based on one or more pre-existing works. And I'll give you an example. The first thing here is a translation. So a translation, let's say I'm interested in Dante's Inferno, which was originally written in Italian. I believe it was one of the first great works that was written in Italian instead of in Latin. And so I'm very interested in this, but it's only in its native language, and I want to prepare an English translation of it. Now, Dante's Inferno was written back in near 1300 CE, so we have to. So that's not eligible for copyright. Okay, the author is long dead, and we'll get to the term later on. But let's just say for now that passage of 700 years has not been kind to Dante's copyright. However, I could prepare a translation that, as long as it's an original translation into whatever language I want to translate it into, that could be covered, and that would be covered by a copyright. I might make let's say there's a musical arrangement. Let's say I hear, let's say there's a song in the public domain, and it's originally written in 4/4 time, and I listen to it and I think, oh, well, that would sound really great in 3/4 time if I change the key and really embellish the chord progression here or something like that, or if I did some sampling and made a hip hop tune out of it or something like that. Again, and I'm using public domain situations here. You can have a derivative work of something that's already copyrighted. So you could have multiple overlapping copyrights in something. You could have the copyright in the original work, which belongs to the original author, presuming it hasn't been transferred. And then you could have a separate copyright in the derivative work. And this is where I think copyright gets a little complicated, because you can have multiple overlapping copyrights, not just between the original work and a derivative work, but we'll see some other examples as we go along. So, and you can do dramatizations, fictionalizations, motion picture versions, let's say, of a book, or a series of articles, or not articles, but installments in a periodical of some sort. There's sound recordings, there are art reproductions, et cetera, et cetera. And you can see that, you can have an abridgment, so something starts out in, let's say, a full-length version, and then it ends up in Reader's Digest. And in a shortened version, that abridgment gets a separate copyright. So there are a whole lot of different things here. And this is just to kind of stir you up and think, oh, maybe this thing is copyright. Maybe I could get a copyright on it. Okay, so what is a work made for hire? So this actually is an important definition. For now, let's just say that a work made for hire is a work prepared by an employee within the scope of his or her employment, or a work specially ordered or commissioned by somebody, and there has to be an express written agreement that it's a work made for hire. So those are the two things. Now, generally, if you hire somebody as an employee, this is pretty straightforward. If somebody's an employee, but sometimes you don't. And so, if there's any doubt in your mind, and then we start to run into, overlapping issues here, right? So what is an employee? Well, it might vary from state to state. I know that in California, where I'm also licensed, if you claim that a work is a work made for hire, there's a presumption, and it's not a rebuttable presumption, by the way, that the individual is an employee. Now, that doesn't really square with the way the copyright law is written. The copyright law, the federal copyright law is written to embrace both employee-made content and work that's been specially commissioned. But under California law, you need to be careful about if you, for instance, if you claim that something is a specially ordered or commissioned work and it's a work made for hire, then you can end up being held liable for their, for withholdings and things like that. It can be very complicated. So you want to be careful of this. I don't believe that limitation applies in Arizona. Still kind of looking into that, so I don't really want to pop off with anything about that. But just keep that in mind. I'll talk about this a little bit farther on, where we talk about, who owns what in copyrights. So what can be protected by copyright? This is a really big one, and it can get a little sticky. This might seem, because it's only 4.5 lines, that it's not that difficult. It says copyright protection subsists in accordance with this title. That's Title 17 of the United States Code in original works of authorship fixed in any tangible medium. You might recognize that word "fixed" there. It popped up in our definitions of expression now known or later developed. Okay, so if somebody develops a new medium, and this actually was written. This was enacted back in 1978, I believe. It was the Sonny Bono Act. So there were a lot of media that hadn't been conceived at that point. Nobody had really conceived of, let's say DVDs, DVRs, and now we have the cloud. Well, what is the cloud? It's a bunch of hard drives or maybe SSD drives, out there to us, it's like it's in the ether. Now, they're actually physical places where these things are recorded, but they tried to write this as expansively as possible in order to catch everything. So I'm going to talk a little bit about, some important concepts here. First thing is it has to be original. What does original mean? Well, it means you can't copyright somebody else's work. Now, I already mentioned in the definition section, you can get a copyright on your own derivative work if you contribute enough to it that it becomes its own work. That's kind of a fuzzy thing there. Well, by the way, a lot of these things they end up being fact issues that are tried to juries. So, you can think about it as, what would a jury of 12 people or 8 to 12 people consider to be, enough to make it copyrightable? So imagine a random sampling of 80 of your friends, 8 to 12 of your friends, and ask, well, what, would they think it was enough of a contribution? And then I have in a question mark form, what about independent creation? And the fact is that if two folks sit down and they write they write, let's say, a screenplay, and they're both basing it on the life of, I don't know, Alexander Hamilton, and they both write some songs to go along with it, and they make it into a stage play. Could they both have a copyright in that? And the answer is yes. The answer is, if they independently created it, even if they end up sounding or seeming very, very similar, they would have independent copyrights. Each would be able to exclude the other from practicing their copyrighted material, but at the same time, each would have their own independent right to copy their own independent creation. So you can see this could be fairly complicated. Fact of the matter, though, is that because copyrighted material tends to be creative, there are an awful lot of different ways that you can express the same idea. So if you can actually prove and this is one of the defenses, and by the way, in a copyright infringement lawsuit, is if you're being sued for copyright infringement, you can claim that there was an independent creation, and you can show, let's say, a paper trail where you created it independently. That's easy today. You have time-stamped, you could have, like I say, a time-stamped email to yourself, or you could even, just have time-stamped files. So these are, bottom line is it has to be original, and originality is actually defense to copyright infringement. Authorship. What does it mean to be an author? Well, you have to have a minimal degree of creativity. And that's kind of important because, there have been some important cases where somebody, for instance, tried to use the copyright laws to sue somebody for copying a phone book. Well, phone listings are, unless you request that they not be public, are actually, considered to be public information. So, and there's the real problem is there's just not a minimal degree of creativity. An alphabetical listing of names with numbers and addresses next to them is simply not copyrightable. What about Yellow Pages? What about all those ads in the Yellow Pages? Yeah, that might actually be copyrightable because they are. There's now, the part that's just a bunch of listings of names and numbers, maybe not, but what about those ads that are in there? And when you start to look at the internet, there's all sorts of internet content that does have that minimal degree, and it's minimal, that it's not super clear in the law where the bar is, but it's pretty low. But a phone book, we know, isn't copyrightable. So it has to be a fixed and a tangible medium. Again, that tangible medium is an expansive term. You may think of the cloud as not being terribly tangible, but in fact, it's not ephemeral. It's not transitory. There's actually somewhere out there's a physical server farm where whatever you've created is living on the cloud. If it's in your computer, it's living on a hard drive or an SSD drive on your computer, or maybe on a thumb drive, or whatever. So those are all tangible media, as is a piece of paper. You write it down. Let's say you create a poem or a song, you write it down on a piece of paper. That's a tangible expression of what was in your head, and so that's copyrightable. Just thinking in your head isn't enough. So if you see somebody express something in writing and you think, oh, I was thinking that, I'm going to sue them for copyright infringement. Sorry, that's not enough. But let's say you recorded it. Let's say you're having these great ideas and you recorded them, and you could prove that they copied them. Now that's, I'm not talking about infringement too much today, but you do actually have to prove copying. That's the originality part of it, right? If they originally came up with it independent of you, then you're out of luck. But it's important to know that just if you say it into a digital recorder of some sort, you have a copyright in that. And so let's move on. There are some categories of copyright protection. I'm not going to go into them in huge detail here, but there are literary works like books and magazines, periodicals of various sorts, musical works, including any accompanying words. That includes sheet music. It includes anything that's recorded on any sort of recording device. Dramatic works, plays and things like that. You can see they recognize there's an overlap between musical works and dramatic works, and they've kind of covered them. So one way or the other, either under 2 or 3, you're covered there. Let's say you produced Hamilton. Pantomimes and choreographic works. So, if you have somebody, if you do a dance and you have somebody shoot a video of you, that's copyrightable. It doesn't matter, you didn't make any noise. That's content. You have a copyright in it. Pictorial, graphic, and sculptural works. Motion pictures and other audiovisual works. Disney wouldn't be what it is today if it weren't for that. And then there are sound recordings, you know, Nashville and LA wouldn't be what they are without that. And then there are architectural works, believe it or not. There's special protection for architectural drawings, for instance. Now, every one of these has some limitations to it, has some caveats to it, but those are all things that have copyright available to them, copyright protection available to them. What can't be copyrighted? Okay, so this is important because it may be an original work of authorship, but if it's just an idea, let's say, so what's not protectable is the idea itself. What is protectable is your particular expression of the idea. I like to use Albert Einstein as an example. He famously came up with the equation E equals mc squared. That's energy, energy produced, let's say, by a fission of a particular atom into two atoms and the expulsion of energy. That energy that comes out is equal to the difference in mass between the two of them separated and the one times the speed of light squared equals mc squared. Now, the way I just said that, because this is being recorded, I can get a copyright in that, even if it's wrong. But the idea equals mc squared, or basically the idea behind that expression, is not copyrightable. So if somebody else came up with some other way of expressing that idea, and many have, probably more correct than mine, then they, I can't sue them for copyright infringement. And it kind of goes along with the same idea of, if you think about it philosophically, it's like, ideas themselves aren't really original. We discover them. You can't copyright a discovery. You see that down here. So, you can't copyright an idea, right? Because it's just something you've discovered. Also, procedures and processes and systems and methods of operation. To a certain extent, those guys are creatures of patent law. If they're protectable at all, it would be under the patent law, certainly not under copyright law. Same thing with discovery. Those are creatures of patent law, not copyright law. So I just kind of broke this out. This isn't a very, I could have added a few things here, but copyright covers an original work of authorship fixed in a medium. Utility patents, on the other hand, which is what we usually mean when we're talking about patents, in machines, processes, compositions of matter, and manufacturers. And then there are design patents. Those cover ornamental designs in a useful article. So you might ask yourself, well, gee, isn't that already covered over here with sculptures? Not really, because if the article is at all useful, if it serves any purpose other than art, then it's not protectable under copyright. It's protectable under design patents. So down here, you see some exclusions from copyright and utility patents. There has to be an ornamental design on a utilitarian article, not just a utilitarian article. So it's kind of hard to get a design patent on let's say a hammer, because there's just an awful lot of hammers out there, and it's hard to do anything new and useful with new in the ornamental design area. But possibly you could. Maybe you do something fancy with the handle that doesn't serve any real useful purposes, but it looks cool. And you might get a design patent. You couldn't get a copyright on it because it's incorporated in a useful thing, right? So I hope that's clear. Maybe I'll clear it up in a later presentation. Probably not. how do you create a copyright? Real simple. You fix it in a copy, you fix a copy or a phonorecord for the first time. Okay. So you make a copy. We define copies. It's basically the expression of authorship in a fixed form or phonorecord. Let's say it's one of the old-fashioned vinyl LPs for the first time. Okay, you create it for the first time. Well, you ask yourself, well, okay, so I typed it in on my computer. Does that mean I've created a copyright? Yes, you have. That's right. If anybody busts into your computer and steals your copyrighted text, then they have violated your copyright. Okay. If you made separate versions, let's say you do a first draft and you decide, hey, I don't, that needs to be rewritten. Let's say you go through the first time and you rewrite it, and then you go, it really could use some work. So maybe you have a friend go through it and suggest some changes, and you go through, third time. Each of those separate versions, it counts as it's a separate work, and it gets its own copyright. So to be fixed, I think we talked about this before. It has to be in a tangible medium. Tangible medium is very expansive, but it can't just be in your head. Okay, it can't just be something you say out loud to somebody and it's never recorded. But if you say it out loud and it's recorded on audio tape, that counts. Again, for the first time, after you have made the original, if you then, let's say, print out copies of it to be distributed or something like that, those aren't each a separate copyright. So you understand the time starts when you first copy it, when you first create the copy. So if you write it down today, you created it today, you don't distribute it for another 10 years. Your first publication is in 10 years, is 10 years from now, but your creation date is today. So let's just talk a little bit contrasting creation with registration. Creation happens automatically when a creative expression is fixed in a tangible medium for the first time. If it's a derivative work, then the copyright and the added portion occurs when the derivative work is first fixed in a tangible medium. Or, let's say it's a translation, right? Well, then it would, when you first created the translation. So you don't have to, if you make a translation of Dante's Inferno, you don't have to worry today that the copyright is already expired. You created this is a brand new copyright when you first write it down or you first put it on your computer or in the cloud or wherever. So registration, and basically all it requires is that you take in some cases, this may not be practical, but in most cases, you submit a couple copies of what you want to register to the Registrar of Copyrights in the Library of Commerce, and then you pay a fee, and there's usually a form to go along with it. The forms are very short. The fees are very low. They're fairly low anyhow, much cheaper than patents, because all they do is they look at it and they ask, is this fixed in a tangible form? Yeah. What kind? Because they want to classify it. What's the subject matter? Because they want to classify it. And is there a minimal degree of expression in there? And they'll ask also, is it utilitarian? Because if it's utilitarian, if it's a bicycle rack and you're trying to pass it off as a sculpture, then they're going to, but the registration system is very short. It's basically pro forma. You send in the money with the form and the copies, you get your registration. So copyright creation is automatic, registration is not. Registration is not mandatory for you to have a valid copyright. Most of what you see out there with a copyright notice on it today is not registered. because it would be impractical for, let's say, the New York Times to register each and every article that's written for them, each and every paper. It's just unreasonable. What they would do instead is, wait until somebody violates their copyright. And when they're about to sue them, they send in the registration, they get the registration, and then they sue. And I said here, if you want to sue in federal court, you need to have a registration. But you can put that off to the last minute, and you don't lose anything by putting it off. The copyright is created, even if it's 20 years from now. You can register something that was created 20 years ago. You don't lose that right because of the passage of time. Who owns a copyright? Well, in the case of a single author, the author owns it. In the case of joint authors, both authors co-own the copyright. In the case of collective works, and this is, let's say, we're going to do an anthology of poetry. So we're going to have 10 different poets involved in the writing of this anthology. Each author owns her own contribution to the collective work, and then they would, and to the extent that it's an integral thing, then the joint authors would own the copyright in the whole collection. Works made for hire. Now, we mentioned this before. An employer or other person for whom the work was made, meaning like commission works, they're considered the author for purposes of determining ownership. Where does this come in handy in consideration? One thing to think about is that works made for hire affect term, and we'll talk about that in the next slide. But I already mentioned that there are also issues that have to do with, it's very straightforward when an employee is actually an employee. It's straight up, no question about it, that person's an employee. It's a little bit more complicated, just in the employment law standpoint, when you start to think about the commissioned works. Okay, copyright term. It's pretty straightforward for authors. It's the life of the author, or a single author anyhow, is the life of the author plus 70 years. That's a nice long time for your heirs to take advantage of your hard work, I always think that's funny, because it's not unusual for, especially classic works, for the author to make far less money from their original works than their heirs do. Oftentimes, things you think about, the many, the works of Sir Arthur Conan Doyle and things like that, or H.H. Milne, or, those folks, their stuff really started making money when Disney got a hold of them, right? So, so there's that single author. Joint works, it's the life of the last author to die plus 70 years. So, if you're going to do a joint work, it'd be good to collaborate with somebody who is going to live a long time. Maybe somebody considerably younger than you who is risk averse and has a healthy lifestyle. If you want to make, or at least if you want your heirs to benefit from your work, if you have an employee or you commission a work, you want to think about works made for hire. That's different. You get 95 years after first publication or 120 years after original creation. So, interestingly enough, if a company stays around long enough, it can see its copyright actually in its original works end up dying after 95 years. And that can be, that can actually be an issue. As a matter of fact, one of the big drivers of the Sonny Bono Act was Disney itself, who pushed very hard for the extension. I believe it was 50 years at one point. Now it's 95 years or 120 years after original creation. I'll just talk briefly about copyright enforcement. Usually first off, normally there's some evidence of copying. Let's say it was somebody, pretty blatantly copied it off your website, or maybe an employee ran off with something and published it, or authors sometimes pitch things to either publishers or movie producers, and then they allege later on that their idea was stolen. So what you want to do is when you create something is you want to put a copyright notice on it. This is your notice to the public that you believe that there's original content in there that is protectable by copyright. It hasn't been examined by anybody. It's not necessary for it to be examined by anybody. All that's necessary for you to give them notice is to put the copyright, this circle C here, the date in which it was created, and you only need the year. You don't get partial years for your 70 plus years, or 95 or 120. You just get the year, and then you write the name of the copyright owner. If it's a company, you put the company name. If it's an individual, you put the individual name. Cease and desist letter. Let's say you found out somebody copied your content, and your first step is usually to send them a cease and desist letter. And you can go ahead and sue them, but the cease and desist letter is a much cheaper option, and you might actually get some compliance at that point. The other thing is that this is constructive notice. A letter is actual notice. If they keep infringing after that notice period, they can be responsible for additional damages, which is always good, and maybe even attorney's fees. State lawsuits, you could file a state lawsuit under common law copyright. You don't need to have U.S. federal registration for that. You just sue in state court. That's really only useful if the individual you're suing resides in the same state. So it's of limited utility, or if they're committing the copyright infringement in the state, you're pretty much limited to the damages in that state in most cases. So it's of limited utility, but it could be useful. Let's say it's a former employee and their distribution is limited. You're not looking for a huge number of damages. You just want an injunction telling them to quit doing what they're doing. That might be enough. But if you want to get into federal court, then you'll need to have a federal registration. And again, like I said, it's quick, it's easy, it's simple, it's cheap. But generally speaking, you don't need to do it until you're like right on the brink of unlike a patent, where you actually need to have an issued patent that has to be examined and whatnot. Registration, oftentimes you can just put in attached to your complaint some sort of proof that you've applied for the registration. It's so pro forma that you will get your registration. So that's all I have on copyright, on the basics of copyright. There's so much more to say about copyrights. It is actually a very robust and complex field. But I hope I've given you enough to kind of get you thinking in terms of, well, maybe this computer program I've written is copyrightable. Maybe this maybe this web content that I've created is copyrightable. Maybe I should keep better records of my copyrights, things like that. Anyhow, so thank you again. This is my contact information down here. I do have my cell that you can call or text this number down here, or you can email me at matt@ntiplaw.com. I suggest if you don't hear back from me, if you've emailed me, that you try texting me or calling me. All right, thanks.
Thank you, Matt. And Matt will be forwarding me this presentation deck so I can forward it out to anybody who wants it. Also, if you missed some parts of this webinar and you need to go back, or you just want to watch it again, you can go to the City of Surprise Economic Development YouTube channel, and all of the recordings are on there. Thank you, Matt, and we'll see you next week, same place, same time for copyright options.
All right. Thanks, Julie.
Thank you. Have a wonderful afternoon.
You too.